Good afternoon, everyone. Greetings from soggy Carlsbad, California. My name is Andrew Hall with the Blake Law Firm, and I am here to discuss some notable new real estate laws that take effect in 2026, which is just right around the corner from us. By way of introduction, as I mentioned, I am a senior counsel and shareholder with the Blake Law Firm. We are a real estate litigation and transactional law firm based here in Carlsbad, California, and we practice throughout the state of California. Uh, this summarizes some of the notable recent legislative changes that we'll be going over today. As you can see, there's 10 that we're going to cover today, but there's been much more than that set to take effect next year. So this is but a small sampling of some of the notable changes. And given time constraints, we're not going to be able to dive too deep into each of these, but there's obviously a lot that goes into each bill and some of the changes. So we'll try to highlight some of the main components of each of these bills. First up is AB 130, and this is a rather significant one that is designed to further the state of California's efforts to create affordable housing by removing red tape and reforming some of the CEQA issues that have popped up. So some key provisions, as you see here, there's a CEQA exemption for infill housing, which creates a new exemption under CEQA for housing projects on sites up to 20 acres. This bypasses lengthy environmental reviews, which can often bog down these types of projects. On a related note, there's a 60-day shot clock that establishes an enforceable deadline requiring local governments to approve or disapprove ministerial housing projects within 60 days. There is a building code freeze. This provides cost stability for developers. It freezes state and local residential building standards. This prevents cities from adding expensive new requirements mid-project that could delay or hinder the project from moving forward. There's a HOA fine cap, which could be rather significant as it amends the Davis-Sterling Act to cap fines that homeowners associations are allowed to levy at $100 per violation. Oftentimes you'll see HOAs have a step up or an escalation of fines. Oftentimes it doubles 100, 200, 400, on and on. But AB 130 caps it, and each fine can only be a maximum of $100. So that could have a rather significant impact on an HOA's ability to fine or discipline its members. And lastly, there's a Permanent Housing Crisis Act protections. It makes several temporary laws now permanent, including the 5-hearing limit for project approvals and the requirement that a site's historic status be determined at the start of the application process. So again, AB 130 is designed to streamline housing projects and create more affordable housing in California. Next up is AB 246. This is known as the Social Security Tenant Protection Act of 2025, and it creates a new tenant protection in unlawful detainer cases. This specifically relates to a tenant who has Social Security benefits that are interrupted through no fault of their own, and in turn end up hindering the tenant's ability to make or pay their rent. It's designed to protect vulnerable seniors along with people with disabilities. And it, again, in particular, applies to federal government interruptions to the Social Security Act. So it allows the tenant to assert as a defense in an eviction proceeding this interruption of Social Security benefits. It does have a limited duration. The pause lasts until 14 days after the federal benefits are restored, and up to a maximum of 6 months. So you want to be mindful if you're if you're a landlord of tenants with Social Security, and if you get to the point where you need to move forward with an eviction, that's going to be an issue that will have to be wrestled with. There's new landlord requirements under AB 246. A landlord must provide a 15-day notice instead of a standard 3-day notice. There's a hardship form that landlord must include. And then there's repayment requirements. AB 246 notably does not forgive rent. The tenant is still legally obligated to pay all past due rent once their benefits resume. But it just kind of hits pause on any eviction proceeding while those Social Security benefits are cut off. There's some important context in addressing 246. The effective date of the law was last year, actually, and it remains in effect until January 20th of 2029. The special eviction protections under AB 246 only apply during an official declared interruption, which the current text is tied to the DOJ determining there is interruption and filing an action. So that it's AB 246 provision is triggered by an officially declared interruption. So that's important to note when evaluating a potential claim under AB 246. Next up is AB 253. Next slide, please. And that is known as the California Residential Private Permitting Review Act. And this is a rather major housing law. Again, moving forward with California's emphasis on creating affordable housing that was signed into law in October 2025. Because it passed with an urgency clause, parts of it took effect immediately. So parts of this bill are in effect as we sit here in 2025 and will continue to take effect in 2026. So the key provisions of AB 253, kind of like 130, are a 30-day shot clock. So when a builder submits a completed application for a residential permit, the city or county must provide an estimated timeline for review. And if that timeline exceeds 30 business days, or if the city fails to review within 30 days, the applicant has new rights. Those include private third-party reviewers. So if a city is too slow, the applicant can hire their own licensed professional, typically a certified civil engineer or architect, to conduct the plan check instead of waiting for the city to complete its review. There is a limited scope to AB 253. The fast track currently applies only to smaller projects. And those smaller projects consist of constructions involving 1 to 10 residential units, remodels or additions to buildings with 1 to 10 units, and buildings no taller than 40 feet. While private professional does the heavy lifting in terms of the technical review, the local building department still holds final authority and say in formally issuing or denying the permit. And this is to ensure that all safety standards are met. Cities are required to post their full building permit and fee schedules clearly on their website to make accessible. So those can't be hidden in various other web pages or pull downs. It has to be clear and obvious now on the website. Next up is AB 301. Again, another law designed to streamline construction of housing. And this one, unlike some of the urgency bills that we discussed a little bit ago, this one officially takes place on January 1st of 2026. It expands the existing shot clock rules to state level permits. So what this means is previously state agencies, think Caltrans or Department of Fish and Wildlife, often delayed projects even after local cities had approved them. AB 301 steps in and requires these state agencies to follow the same strict timelines as the local agencies, cities, or counties. But this applies to post-entitlement permits. So permits needed after the main project is approved. Again, think grading or utility permits, for example. There are strict timelines referenced under AB 301, 15 business days for an agency to tell a developer if the application is complete, 30 business days to review projects of 25 units or fewer, and 60 business days to review projects with more than 25 units. Additional key provisions include a deemed approved trigger. So if a state agency fails to meet these deadlines, the permit is legally deemed approved, which can be rather significant, and any delay, could result in a permit being deemed legally approved. This is obviously a powerful tool for developers to prevent projects from being stalled or backlogged, and it is certainly an incentive for state level bureaucracy to work through these permits much quicker. And as we alluded to earlier, the website transparency, by January 1st, 2026, all relevant state agencies must post clear permit application checklists on the websites. AB 414 is a bill focusing on modernizing the return of residential security deposits. It was signed into law in October of this year and goes into effect on January 1st, 2026. The bill fundamentally shifts the default method for returning deposits, and the push on this, or the emphasis, is to reflect the trend of digital payments and kind of modernizing the return of defaults to reflect the mode of payments that are typically made. So if a tenant paid their initial security deposit or the rent electronically, so think a portal or Zelle or Venmo or things of that nature, direct deposit, the landlord is required to return the deposit in the same manner in which the landlord received the deposit. There is an exception to this. Obviously, the landlord and tenant can agree in writing to use a different method, such as a paper check or some other method that's different than how the deposit was initially made. But the default is the digital return of the payment must be made digitally unless that agreement is made in writing between the landlord and tenant. Landlords can send these statements via email. And again, this requires written tenant consent to do so. Unlike previous laws that restricted when consent can be given, AB 414 allows landlords and tenants to agree electronic delivery at any point, including at the start of the lease. AB 455, this is another law that goes into effect on January 1st of 2026. It requires sellers of single-family homes to disclose in writing of any known history of smoking or vaping, tobacco use, or use of nicotine products on the property, including any residue from such, to prospective buyers. So this will be a requirement in the disclosure documents that sellers are required to send to buyers. Third-hand smoke is classified as an environmental hazard, and it's been found to be comparable to asbestos, radon, or lead in California. So AB 455 is designed to put that smoke use or tobacco use or nicotine use into the same realm as those issues. The law also requires the Department of Toxic Substance Control to update the environmental hazard guidelines for homeowners to include information about third-hand smoke. AB 628 requires landlords to provide a working stove and refrigerator in all new, amended, or extended residential leases starting on January 1st, 2026. And the significance of this is that the law adds that these appliances are now characteristics required for a dwelling to be considered tenable or habitable under California standards. So if a property does not provide a working stove and refrigerator, the property could be found to be uninhabitable, and it could create an issue between the landlord and the tenant. AB 723, this law or bill requires real estate brokers and salespersons to disclose when property listing images have been digitally altered or AI enhanced, and to provide the original unaltered images alongside them. The design, as you could surmise, is to prevent misleading visual representations of listings and to accurately reflect a property's real-world condition. It does not apply to minor photographic adjustments like brightness or color, but virtual staging or significant alterations must be clearly labeled. And again, it's designed to prevent misleading prospective purchasers. AB 2159 it modernizes homeowners association elections. This was actually signed in September 2024 and took effect in January 1st, 2025. But it's going to be heavily emphasized in 2026. Before this law, the Davis-Sterling Act effectively required HOA elections to be conducted via secret paper ballots. AB 2159, like we discussed with the security deposits, is a move into a more modern digital age. So what this means is HOAs are now authorized to conduct elections using electronic secret ballots. These can be done via email or a secure website. This was not allowed before the implementation of AB 2159. Elections regarding assessments still require a physical written secret ballot. So you'll need to be sure that you understand what the election pertains to. As long as it doesn't apply to assessments, it can be done via a digital website or email. Another key provision of AB 2159 is it does not allow the HOA to force everyone to go digital. So it does require a hybrid approach. It gives HOA members the option to either opt into electronic voting or continue with the paper voting if they so choose. The paper method is still the default method. So if a member does not explicitly choose to go digital, then the default method is a paper ballot. There is a 90-day deadline. Members can change their voting preference, but it must be done at least 90 days before the election to take effect for that cycle. Third provision is for consideration is security and authentication. The law sets a high technical standard for any online voting system used by an HOA. So if they do go digital, it must authenticate the identity of the voting member. It must ensure secrecy, so permanently separate the member's identity from their ballot, so no one can see how a specific person voted. And this includes secrecy from any board. And then issue receipts. So send an electronic receipt to the member after they cast their vote to confirm that the vote's been cast, and then maintain an audit trail. So the HOA must provide a secure tally sheet for review, or this is for purposes of if a recount is needed, there needs to be a trail of the votes. There's end of floor nominations under AB 2159. What this means is if an HOA chooses to use electronic voting, they must prohibit nominations from the floor during an annual meeting. So the electronic voters have the same candidate list as those attending in person. And HOAs, in order to comply, they must amend their election rules. So if they do want to implement the digital voting, the election rules must be amended to reflect as much. The board must formally update the election rules to allow for voting in order for digital voting to be allowed. The members must be notified of the new rules and given 28 days to comment before the board adopts them. And most HOAs will need to hire a third-party vendor to ensure that the requirements under AB 2159 are met, including the secrecy and other issues that we discussed here earlier. So that was a quick whirlwind view of some of the laws taking effect in 2026. Obviously, it's very summary in nature, the way we went through everything. So I would encourage you to look deeper into any of those laws if you think it might apply to your situation or your scenario. If you have any questions or would like to discuss them in more detail, we're happy to do so. And we stand by the ready to help advise you on these laws or any new ones taking effect that we didn't necessarily cover in this webinar today. So please feel free to reach out. We're happy to help, and we look forward to discussing these changes with you. Thank you.